Court District Court for County of Western State of Michigan is now in session. All those having been for the court draw near, the Honorable Judge J. Sessions to preside.
You may be seated. Oh, no, not no, anybody but McDuffie. You got everybody there to choose from and you pick McDuffie. Okay, Miss McDuffie, go ahead.
Good morning. The people waive any conflict between this honorable court and the office of the public defender for all cases on today's docket. The people do not believe that a conflict exists, but we make this waiver for the avoidance of any else.
I'll blame you, Childers. Oh, I get a choice? You know who I'm choosing. No, Miss Mackey?
Good morning, Your Honor. Hannah Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Laura Brown.
Permission to practice is granted.
Thank you, Your Honor. Honor, we waive any potential conflict between the honorable court and our office, and if any conflict will arise, we waive that conflict with the honorable court to hear these matters.
Thank you. That was so nicely done. The court, for its part, does not believe that there is any conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People State of Michigan versus Gene Giles. They're all on Zoom.
Good morning, Your Honor. For the record, Rita Young, P44626, appearing on behalf of the defendant, Mr. Jermaine Gene Giles, who is present by Zoom.
Sir, can you state your name?
Jermaine Gene Gillis.
Gillis. All right, thank you. All right, what are we doing on this?
Your Honor, requested a preliminary examination in person.
And you have all of the discovery?
I'm still waiting on the DNA test results, Your Honor, but I don't want to, we've been waiting for a while, so I want to move forward. Hopefully the prosecutor will provide those documents before the exam date.
An update on that, Your Honor. I have a note from APA Lonnie from the last PCC where she stated she sent an email to Ms. Young, and Ms. Young actually replied to that with confirmation. She stated that she was able to confirm with the plan that there will be no further testing on this case, so we can go ahead and send this to court. So no DNA results are forthcoming.
There, did you hear that?
Not clearly, Your Honor.
There'll be no DNA testing. There's no further testing. There'll be no DNA results coming.
Okay, very well.
All right, since we got to arrange for transport from MDOC, preliminary examination in person will be set April 22nd.
Judge, I have a
2000. Pardon?
I'm so sorry. I start a homicide trial in Wayne County on the 21st. That's going to last about a week.
April 29th, 2025, 9 a.m. That is before. That's before me.
Okay.
Just call me lucky. All right. Thank you.
Thank you, Your Honor.
Bond continued. Thank you, sir. Court calls the case People versus Robert Braxton.
Good morning, Your Honor. This is for David Ferguson and Robert Braxton, who's appearing via Zoom from the Michigan Department of Corrections.
Mr. Braxton, can you state your name, please, sir?
Robert Braxton.
I have before me a plea form. Is that what we're doing?
It is, Your Honor. I discussed it with my client. He's ready to proceed.
All right. Plea form indicates that the defendant will be pleading guilty to 2 charges, added counts 5 and 6. The 5 being attempted possession of a firearm in a motor vehicle, a misdemeanor punishable by up to 1 year incarceration and a $1,250 fine plus court costs, and then added count 6 of attempted resisting and obstructing a police officer, also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Upon a successful plea to that charge, counts 1, 2, 3, and 4 would be dismissed, and there's no objection to a time served sentence. That's the court's full understanding of it.
That's perfect.
Mr. Braxton, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Robert Maurice Braxton.
Sir, it is the court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. First charge being an added count 5 of attempted possession of a firearm in a motor vehicle. It's indicated that's a misdemeanor punishable by up to 1 year incarceration and or a $1,250 fine plus court costs. You understand that?
Yes.
It's also this court's understanding you're going to plead guilty to an added count 6 of attempted resisting and obstructing a police officer. That being a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge unless we proceed to immediate sentence. But you understand I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay. I thought I was going to get sentenced today.
Mr. Braxton, but I'm not sure if Judge Simpson's going to or not.
They never know what I'm going to do.
Okay.
All right. The good thing is neither do I. What?
While I would be fine with immediate sentencing, the reality is to count to the attempt.
Yes, it is. I have to send it to Judge Washington because it's a DR. You're right. All right. So you understand that, sir? Mr. Braxton? Yeah, we've lost it. I've lost the audio. Let me pass the matter. Can you put in the chat so that you can't? Okay. Court does call the case People versus Jenny Liu. 2 cases.
Assistant Public Defender Chelsea Brazil, with and on behalf of Jenny Liu, please state your name.
Jenny Liu.
Good morning. All right. You're asking for an adjournment of this.
We have not been able to visit further assault and attorney on another case we've been attempting but unsuccessful.
To
To follow the process of getting approved as a visitor and then scheduling. Ms. Tierney has gotten through step 1, but now she's having to go through step 2. I have not even been approved as a visitor, unfortunately.
All right. Is anybody in your office aware of how much time this is taking? Because this is the first case.
We are
Thank
definitely
you.
aware and we apologize for that, but we are trying to follow the extensive instructions provided to us by the Grand Valley's facility.
Right. I understand that, but are we looking at a month or are we looking at a shorter time period?
I would say a month to be safe. Now that Ms. Kearney is approved, once the scheduling spot opens, she should schedule that and discuss the offer with Ms.
All right. Probable cause conference, April 24th, 2025, 9 a.m. Bond will continue. Thank you, Ms. Liu.
So Judge, am I just waiting for them to come see me?
In part, yes, they have to come talk to you, but they've got to get through the process to even be able to have a visit with you.
The visitation. Yeah, I was aware that I thought they had already got that all cleared up.
Whatever it is, not just because of your case, but it seems to be a mess on NDOC's part, trying to get people approved. So I know they're working on it hard with your case and with other cases. All right.
Okay, sir. Thank you.
All right. Thank you. Court calls the case of the People versus Devin Gibson.
Please, example, Court Brandon Bird on behalf of Devin Gibson.
He's in. Okay.
Yes.
Sir, can you state your name?
Me, Devin Gibson.
All right. All right. What are we doing? You're requesting an adjournment?
Yes, ma'am.
Probable cause conference will be adjourned. It's 2 weeks out, the 10th. April 10th. Will that work for you, Council? April 10th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Commission to address my.
Go ahead.
18-year-old lifelong resident. He is spoken to presumption and innocence in this matter. We do have his father here who supports him, so he has significant community ties. He understands that there's gonna be no contact between the witness and, respectfully, Your Honor, my client indicates to us that, even if she needs to tell it,
Go ahead. You know what I'm saying?
we respectfully request the personal boundary tether, at least to lower it.
Response.
Thank you, Your Honor. First, I want to ask if the court has a copy of the prosecutor's bond recommendation form. It's fine.
I do.
I wanted to ask if the court would go to that. You will see that, the authorizing APA on this case originally requested a cash or financial bond of $500,000 cash surety. I believe that what was actually ordered was significantly reduced amount, if I'm not mistaken, of $50,000 with a 10% privilege on top of that. I think the recommendation form will get into detail about some of the concerns on this case. There is GPA charge, and there is apparently a very bloody scene in this residence, including several counts of RNO with damage to a police vehicle and an ethnic intimidation charge as well. We're very concerned about the safety of the community in general, based on that. So the people would ask that this significantly reduced bond was originally requested.
Anything additional, Counsel? Motion for bond reduction is denied. Bond will continue. Thank you.
That's it, correct.
Court calls
You
the
do
case
that
people
tonight, girl, once
versus
you put her
Warren.
hands on me, though.
Oh. Do we need it to go back up? Okay, no, leave it alone. Okay. You're a nicer person than me. Court calls the case people versus Warren Abbott.
And her children's appearing on behalf of people.
Stephanie Cannon, on behalf of Mr. Abbott.
Wow, in the room,
Please state
in
your name
the
for record.
room, in the room. Thank you, sir.
And Your Honor, I've spoken to my client about the options that he has. He has elected to waive over to circuit court.
All right. Is that correct, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single charge. Ms. Cannon.
Your Honor, at this time, my client will waive formal reading of the information, and he can mute as to the charges.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
April 9th at 1:30 before Judge Conlon.
April 9th, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls the case of people versus Rafael de la Cruz.
Good morning, Your Honor. This is Robert Ianni, Special Assistant AG on behalf of the people.
Hunter Alexis, my appearing with and on behalf of Mr. De La Cruz.
State your name, sir.
My name is Rafael Cruz.
All right, thank you.
And Your Honor, we are requesting an adjournment. Mr. De La Cruz posted his bond at the end of February. Since then, he's paid an additional $2,000 towards his arrears. So we are just asking for an adjournment.
Any objection from the people?
Yeah, we would like to see him start making monthly payments, Your Honor. He does have 2 children in need of support. I mean, I don't mind dragging this case on as long as he's making his monthly payments.
How much are his monthly payments?
Your Honor,
$350, Your Honor.
350. He paid the additional 2,000 at the beginning of this month, which went obviously toward the arrearage as well as his monthly payment. So
That's correct.
all right. All right. How much time were you looking at?
if we could go out a month here.
Probable cause conference, April 24th. 2025, 9 a.m.
April 24, have it, Your Honor. Thank you.
Thank you. Bond continued. Court calls case People versus Stephen Bauer.
Again, Your Honor, this is Court David Burgess. On behalf of Stephen Bauer, who's approaching. Stephen Bauer?
All right. And you're requesting time to get the
2 weeks, Your Honor.
2 weeks to do.
Pretty much still reviewing some discovery, and we're not sure if there is additional discovery, but we need to review it anyway, so we're requesting 2 weeks. That's correct, Your Honor.
April 10th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus James Belleville.
Rodriguez on behalf of James Belleville.
Mr. Belleville?
Yes, Your Honor.
All right.
Good morning, Your Honor. We have been working on paying restitution. I can provide a check to you, but I understand that you're pay restitution, that's the cash report.
Yes.
So I'm gonna, we're looking to try.
And it needs to be paid at 14B. Yes.
I'm gonna work on facilitating that, and I have 2 weeks.
2 weeks. Without objection, probable cause conference April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Stevie Brooks.
Yes, Your Honor. Brandon Bird on behalf of Stephen Brooks. Take your full name for the record, Stephen Brooks.
Thank you. All right.
Your Honor, may we briefly approach on this matter?
Counsel too? Yeah. Yeah, okay, come on. Record should reflect we've had a brief bench conference in this case. All right.
Yes, Your Honor, we'd like to set this matter for a
Preliminary. All discoveries complete, counsel.
discovery.
All right. And would the people have their witnesses available the 8th?
We'll do our best, Your Honor.
All right. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo. Bond, go ahead. You want to address Bond?
You were about to say, especially my clients are sitting, my clients in jail roughly a little bit over 2 weeks now. I do understand you have previous actions, my client reached out over the phone, but he understands the consequences of those actions at this moment. Respectfully, his phone privileges is revoked right now. He does have a lot of business that he needs to attend to, at least to sort of keep his life going. He's closely enough in the innocence at the moment, and if he is found to be innocent, then his life will be impacted significantly by him sitting in jail, or at least not being able to make any phone calls to handle the jail. I do understand these are serious assaultive allegations, but my client is ready to face those allegations, maintaining his innocence in this matter, and respectfully, Your Honor, we're asking that this honorable court give my client a chance, even if it's with the GPS tether, or even if we at least become more lenient on his phone call, so that he's able to keep his life in some sort of balance while he's locked up.
Respond. Will object to any modification of bond. As the court heard, he had previous jail calls that weren't addressed that were to the victim after he had been arraigned. He also has numerous dismissed DV cases. He has a detective from 2021 on another dismissed from firearms and DV cases. And in these cases, there's at least 4 instances of him terrorizing the victim, in which he is throwing things around the house, taking her phone, pushing her against the couch, taking her phone again, pushing her on her chest, grabbing her wrist, pushing her around the house, taking her phone again, throwing her down on her stomach, stomping on her back, grabbing her by her hair, slamming her to the floor, and choking her.
So I have extreme concerns for her safety and would object to any modification of bond in this case.
And that's allegedly, that's allegedly. My client has proven to, have performed those actions against that person. And I ask you, please don't use domestic violence cases against my client, or at least assume that he's guilty or that he had something to do with those cases. Because if we want to make assumptions, we could assume that, somebody may be lying on him and trying to use the police against him because of, what they might be going through in their relationship that's not assault of marriage. So, respectfully, Your Honor, we're looking at this case on its face. I do understand the assault of nature. I do understand we have that phone call. But my client got his phone call revoked, not able to speak to anybody, been sitting in jail over 2 weeks. He understands the severity of those.
Yeah, but that's by his own due. I mean, it's not as though we just decided to sort of hold him incommunicado. The problem is that he couldn't follow the conditions as we laid them out. So if I released him, what would make me think that he would follow any of the conditions that are set right now? He didn't do it before.
There's ways to mitigate that, Your Honor. There's ways to mitigate that with the GPS test, even if it's house arrest. With a GPS test, if he steps out that house, then he's gonna be arrested.
Couldn't follow the conditions when we first gave him to him. Motion for bond reduction denied. Bond will continue. Thank you. Court calls case People versus Julian Word.
Christina Costantino appearing on behalf of Mr. Word. Mr. Word, can you unmute or ask someone to help you unmute and state your name for the record?
I'm unmuted. Julian Word.
Because this is a date and time set for a PCC. At this time, we would be asking for an adjournment so that I have some additional time to review discovery with my client, who's currently housed at Wayne County Jail.
All right. Did you want the 10th or the 17th?
The 10th would be great.
All right. Without objection, probable cause conference, April 10th, 2025, 9 a.m. Bond will continue in this case. All right.
Thank you very much, Judge.
Thank you. Court calls case People versus Derek Graham.
And then on behalf of the people, Your Honor.
David, Goldstein, on behalf of the defendant. Your Honor, I was just recently detained in this matter. I do have the written discovery. However, I was informed this morning that there is some electronic media that I have not received. So I'm asking for 1 week.
Will all of that be provided within a week?
Yeah, you already have it in our file. We sent it over to Mr. Goldstein.
Probable cause conference then will be adjourned April 3rd. In both matters, 2025, 9 a.m. Bond continue. Court calls the cases of the People versus Samantha Warren. All right. Your name?
There should be a waiver while we're waiting.
You're waiving on all 4 cases.
That's correct.
All right. Mayor, is that correct that you're waiving preliminary examination in all of these matters?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have those hearings and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right on all 4 matters.
Yes, sir.
Preliminary examination having been waived on the single count in each of these cases, defendant is bound over to circuit court.
Your Honor, we acknowledge the information in each matter.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in these matters will be set for
May 19th at 1:30 before Judge Booth.
May 19th, 2025, 1:30, Judge Hamud. Bond will continue. Thank you. Court calls the case People versus Don Lee, 2 matters.
People, Your Honor.
So we're gonna send Burke's number, I'm having to wait.
Your name, sir?
John.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
Couple weeks will work, or?
Yes, Your Honor.
All right. Without objection, probable cause conference, April 10th, 2025, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
Thank you.
Your Honor, could I have one request before?
Certainly.
I know we had last week, phone call, issues, phone calls. And I'm still listening to the calls and we'll file a motion if appropriate. Mr. Lee is wondering if he's able to at least call his mother instead of having all of his calls restricted. If that's possible to work out.
Any response?
Your Honor, we would have a strong objection that he was mailing letters to his mother to get in contact with people. So that would be
And I recall all of that, so I'm going to deny that request. Court does call the case People versus Larzell, Washington.
Good morning, Edward Rubik's on behalf.
Okay, yeah, but
I'm requesting an adjournment to get back.
are you? Your client would request it if they were here. What a concept. Well, a week would be enough? Yeah, okay. Bench warrant will issue for defendant here to appear. Bond is set in the amount of 10,000. Cash surety, that warrant will issue immediately. Thank you. Court does call the cases of the People versus Tyve Mills. 3 cases.
And your children preparing on behalf of the people.
On all 3.
Yes, right.
Council approach. Or would the people have their witnesses available the 8th?
And I was gonna say, Judge, my only issue, Judge, is that I am in trial on Thursday, before the 7th, 8th, and 9th. Is it possible to do this the following week at all?
The 15th?
That will work.
Any,
I was actually gonna ask, just there, because of the number of witnesses and cases, I was gonna ask. For 15 minutes.
all right. And that's gonna be, I'm gonna keep this one. Preliminary examination in person, April 15th, 2025, 9 a.m. That's before me. On all of these matters.
Thank you, Judge.
Got there anyway. Bond will continue. Thank you, sir. And can you take it? No, it's okay. Court calls the case People versus Robert Trombley. Back.
And your children preparing on behalf of the people.
Yes, Your Honor, Brandon Bird on behalf of Robert Trump, can you please take your form? Robert Trump.
Thank you. All right, what are we doing?
We'd like to say this matter for the time.
All right. All discoveries complete.
Yes.
Would the people have their witnesses available the 8th?
That's fine.
All right. Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Barr. Bond will continue. Unless you wanted to argue at council. I mean, no, okay, all right, I'm just. Okay. All right. Thank you, sir. All right, take care, sir. Court calls the case, People versus Jeffrey Stoops.
People, Your Honor.
Public defender, how do we speak with him on behalf of Mr. Stoops in the case that we 1742
4-0.
Your name, sir?
Yeah, good morning, Mike, Jeffrey Allen Stoops.
All right. You're requesting an adjournment.
I am, and I do believe Mr. Drugas did state to me he was requesting an adjournment in my case, or in his case as well. Mr. Stoops has been referred in my case to the 14B recovery court. I've been in contact with Mr. Ray's down there. He has not yet been down to jail to screen Mr. Stoops, but he states he is going to. I believe that'll be done sometime early next week. So I'm just requesting a 2-week adjournment of my case.
I have the written form. Where's Mr. Drukas?
He's right in that hallway. He did say he was going to adjourn it at 12.
Yeah, I know, but I have his client. I need the attorney. I mean, Mr. Drukas, you're requesting an adjournment also on Mr. Stoops? Yes. All right. Yes, hold on one moment. So how much time, there's a referral that has gone over to 14B. I presume you're tagging along with that. So where is it in that process?
I would just ask for 2 to 3 weeks, Your Honor. Mr. Ray hasn't met with Mr. Stoops yet, but said that it's on soon. So I don't know for sure if he had been answered within 2 weeks, but I would ask for 2 to 3 weeks.
All right, why don't we do the April 17th, 2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to our attention that he has made 51 calls since his arraignment to the victims. He's been calling his phone when it is the victim that answers. In talking, they use a code name calling her Aunt Diane, but it's the victim. So we would have concerns that he's contacting her by using his own phone number and that's his phone privileges.
With regard to that, I haven't heard any individuals.
Any response to that?
No,
You're presuming it's not on your case.
So, yes, I would.
Well, you'll be entitled to certainly file a hearing once you hear all of the calls, but at this point, I'm going to revoke the defendant's phone privileges. His bond in each of these cases will continue.
Thank you, Your Honor.
You know what? When I call you, I'm gonna use a code name. Yeah, no, I'm gonna do that. I think because that'll work. I think that's the case. People versus Joseph Hamby.
Good morning, Your Honor. Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
Good morning.
On behalf of Mr. Kennedy, evaluation case 24F1-1672.
And Cheryl Foster Tucker on behalf of Joseph Hamby in the case ending at 9.
All right. On your case, you're waiving.
Yes.
What are we doing on the other case?
Yeah, we're gonna set that one for a preliminary exam.
All right. So let's set, discovery is complete on that case.
Yes, Your Honor, to the best of my knowledge.
Would the people have their witnesses available on the 8th?
I see no reason why we wouldn't, Your Honor.
All right. Preliminary examination in that matter will be set in person, April 8th, 2025, 9 a.m. That is before Judge Valvo. In that matter, bond will continue.
Thank you so much, Your Honor.
Thank you. In the other matter, sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. All right. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Go on.
Wait formal reading, standing for the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for May 19, 2025, 1:30, Judge Hammoud.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. One of my
Thank
staff
you.
can find that information. Papa Childers.
Yeah,
assistant-
they're all like all out of control here, Ms. Burton Harris. So we'll see if we can track one down. It's been something this morning.
Doing their best, Judge.
All right. Thank you. Court calls the case, People versus John Zock. Well, he's coming out. Mr. Braxton, can you now hear me?
Good morning, Your Honor. It's always good to see you. Robert Ellman with on behalf of Mr. Zock. John Andrews.
All right. Good morning.
Your Honor, please take the time to have the probable cause conference. We will be waiving preliminary hearing at this time. I believe you could have a sign.
I do. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 4 with 5 and 6. Mr. Allen.
Yes, Your Honor, and we would waive any formal reading and standing.
Defendant having waived formal reading, standing mute as to all counts, court will enter a not guilty plea. Pretrial will be set for
April 9th, 1:30 before Judge Conlon.
April 9th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you.
Have a great day.
You do the same. Mr. Braxton, can you talk back to me now? I don't know what's going on. Mr. Braxton, if you can hear me, wave your hand. Now, this is even worse because I'm getting nothing now.
Yeah.
I'm not getting a response at all. I think that's frozen. Yeah, we're gonna have to. We'll try to get it through. I don't know. Court calls the case, People versus Isaiah Levy.
Good morning, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And good morning, Your Honor, to the staff and people on the report. Mohammed Nasser, P7445, on behalf of Mr. Isaiah Levy. With your standing, all right, sir. State your name for the record. Isaiah Levy.
Thank you. What are we doing?
Judge, may I please report? I didn't realize the attorney's record would be the deputy chief. I didn't have a chance to speak to him. We did receive discovery yesterday. However, your staff did advise me that we failed to file the substitution of attorney. I'll do so immediately. I'd like to set this for a new PCC so I can speak to the prosecutor in regards to a resolution. I'll wait 14 and 21 day rule, Judge.
Probable cause conference, April 10th, 2025, 9 a.m.
Thank you so much, Judge.
Thank you. Bond continue. Court calls case, People versus Christopher Willis.
Andrew Childers, bring on behalf of the people.
Edward Dripps on behalf of Christopher Willis. Your Honor, may I have a question, prosecutor?
You may. He still has a current bench warrant out on it, but it shouldn't be. It should have been canceled on his arraignment. Yeah. Yes, it's been revoked. All right. Record should reflect who had a bench conference in this case. Probable cause conference will be adjourned for 1 week to the 3rd, April 3rd, 2025, 9 a.m. Bond will continue as revoked. Court calls case, People versus Amin Benin.
Your Honor, Assistant Public Defender Constance. Right, for the record.
Amin Ben.
Thank you.
Your Honor, today's the date and time set, please. See at this time with respect to requesting a separate.
All discoveries complete. People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. Bond or before Judge Barr. Start going somebody at place house. Bond will continue. Thank you. He moved. Mr. Braxton, can you hear me?
I can hear you now.
Okay, now we can hear you too. All right, they got us straight, I think. I'm gonna call that case. People recall, court recalls case, People State of Michigan versus Braxton.
Andrew Childers, attorney on behalf of the people.
Good morning again, Your Honor. May the police assault the court, David Curtis, on the Braxton, who's again appearing to in the Michigan Department of Corrections.
All right, and I think we had gotten to the point where I'd apprised you of the charges and you understood the charges you're pleading to, correct, sir?
Correct.
And you understand that because of count 2 was a victim's rights case, I can't do immediate sentencing. So you understand that?
I do understand that.
Okay, very good. So, sir, to the charge of attempted possession of a firearm in motor vehicle, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
I do.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
No, I'm not.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
I am.
And because you believe that you're guilty of these offenses?
Yes, sir.
April 4th, 2023, at the location of 2861 International Drive, Ypsilanti Township, Washington County, State of Michigan. Were you in a motor vehicle?
I was.
Did you have possession of a firearm while you were in that vehicle?
There was a gun in the car. Yes, sir.
Okay. And did you know it was in the car?
Yeah.
Yes. Okay. Thank you.
Yes.
And you didn't have any authority to carry that weapon in that fashion, did you, sir?
No, sir.
All right. You at some point came into contact with police?
I did.
Probably didn't go well. What happened?
I tried to run.
Oh. That didn't work.
No, sir.
You knew they were trying to arrest you?
Yes.
All right. Counsel? All right. Court will accept the defendant's plea of guilty to counts 5 and 6. Counts 1, 2, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be May 1st, 2025. What time? 10 a.m. before Judge Washington.
Okay.
All right.
All right.
Bond will continue. All right. All right. Thank you. Take care of yourself, Mr. Braxton.
All right. Take care.
Court calls case People versus Gerard Brown Hughes.
People, Your Honor. Stephanie Cannon on behalf of Mr. Brown Hughes.
Oh, that could have gotten ugly. All right, what are we doing on these cases?
Your Honor, Mr. Hughes is going to waive circuit.
In both matters?
Yes, Your Honor.
All right. Is that correct, sir?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that by waiving that proceeding, you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right in both cases.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count in the case ending 1101 and on count 1 with 2 following in the other matter. Ms. Cannon.
Thank you, Your Honor. We would like to believe that the information standing on the charges.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 7th at 1:30 before Judge.
April 7th, 2025, 1:30 before Judge Hamud.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue.
Thank you.
Call the cases of the People versus Beverly Boss. They need to sign off.
Yes, public defender Natalie. Probably went and on behalf of Ms. Boss, who should be dialed into Zoom, Your Honor. She called the public defender's office this morning. She talked to several of the legal assistants. She's actually sick and she was having trouble logging onto Zoom, but I believe she was finally able to successfully dial in. If she's using her father's phone, the last 3 numbers would be 238.
Nope. I have one call in.
I'm
Could
not
be.
sure if that's the number she's using. If it's her father's phone, it would be that number.
Ms. Boss, if you called in on Zoom, I only have one number, but if you called in on Zoom, you'll need to hit *6 on your phone to unmute.
Hello?
Oh, hello, what's your name?
Hello. Beverly Boss?
Okay, that's her.
Awesome, thank you.
Yes, that's me.
So, Your Honor, I have discussed this matter with people. I was planning, Ms. Boss and I have not been successful in having a phone conversation prior to today. I was going to give her an update this morning in person, but obviously was unable to be accomplished. I would ask her to only be loud. I understand if 2 weeks.
It's gonna be 2 weeks.
I can understand, Your Honor. Thank you.
Nice try, though.
Your Honor, no objection, but I did want to inquire about mine.
Oh, boy. Probable cause conference, April 10th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, so Ms. Boss, as the court is likely aware of the nature of the case, has a longstanding history with, I think multiple substances, including alcohol. One of these is an OWI case. I think it's her. As one of these counts relates to the.
No, I don't. I don't have an OWI.
It isn't. I'm sorry. One of these counts relates to the removal of a scram tether for such a case. I am inquiring if she is currently on an order. I saw that when she was arraigned on these cases, that I didn't see a community corrections order for her. So given the nature, I think, of the charge, I want to make sure she says it.
Ma'am, are you?
Hello?
Are you on a scram tether?
I was on a scram tether and I had, and a long time ago, and something had, I thought it was in the cases with what we are going through now. It was a part of the bond too. I bonded out on the cases.
Okay, but are you on a scram tether right now?
No, I'm not on any kind of tether.
I believe that is correct, Your Honor, that she is not on a scram tether or under order to be on a scram tether, my understanding.
Okay, so how does somebody get out for tampering with a device and then not get put back on the device if that were?
So that was on.
I'm sorry for being too logical. Yeah, go ahead.
So that was for another case that she was on probation for in circuit court. Then allegedly something happened with that scram tether, which then the charge initiated. She has been on bond in both these cases for some time, previously referred for competency, was at the forensic center. It's found incompetent but restorable, has been restored. It's now it's a finding of competency. That being said, I don't believe she was ever under any order in either of these cases, to my knowledge, to be on a scram tether. And none of the charges in either of these cases are an OWI.
So, but the
Yeah, that don't make sense. I did a year in the county jail. I got raped, my tether cut off. And then I did 365 days, turned around, did another 6 months. And then they pulled up charges on me for tampering with my tampering device. But me and my lawyer and the safe house with the other judge, I think it was non-prejudice to come back at me with the tether tampering. So all of a sudden,
I
they just
see. Okay. I got it. I'm not gonna change anything. I'm just gonna leave it where it is. Because I see the dates and so Bob will continue.
Thank you, Your Honor.
what was the date, Your Honor?
Yes, ma'am.
What was the date again? April what? 9th
10th.
or 10th?
April
At 9
10th,
o'clock.
2 weeks from today.
Okay, thank you, sir.
Thank
Thank you, Your
you.
Honor.
Thank you, Ms. Boss. We'll be in touch again.
Okay, thank you.
Court calls the cases of the people versus Elijah Craft.
And then we have the people, Your Honor. Morning, Your Honor. Lord Daddy, Assistant Public Defender, with on behalf of Mr. Kraft, who is approaching. Oh, oh my gosh.
I know, every week.
Every week.
I know.
don't know what it is.
Well,
In both matters. Mr. Kraft, could you state your name to the court?
what are we doing?
Your Honor, we have discovery in one matter, but not in the second matter. So the case that is ending in 0342, we have media discovery that's missing with reference to the police report. I'm hoping that the APA may have an update about that. Your Honor, we do have a media notice in the file, so I'll get that filed over today.
I'll grant the adjournment. You wanted the adjournment in both cases.
I do, Your Honor.
All right.
I would ask for a week if the court would give it to me. I do want to address bond though. So the bond issue may impact the my request as to when the next court date should be.
So depending on what I do on bond, depends on what she's gonna ask for. However, having no bearing on what I'm gonna give.
Yes, Your Honor.
Why is everybody trying to trick me today? Go ahead.
Thank you, Your Honor. So Mr. Kraft has been in jail since March 14th. He was arraigned on the first case on March 16th. And the second case, he was arraigned on March 20th. Now, the bond form stated that he was on bond when the second case arose, but that's actually not accurate because it was a delayed authorization. So he has been in jail since March 14th. He's not been released, correct? And so the first case, he was arraigned on the 16th. The second case, he wasn't arraigned until the 20th, but the alleged offense date back to March 11th. I do want to note that both of the individual girls in these cases are girls that Mr. Kraft has had prior relationships with, one of whom is his child's mother, and another is ex-girlfriend. I do want to note that in the case ending in 0324, he is charged with multiple charges, including larcenies of firearms, but the police report verifies those firearms were not actually registered to the complaining witness, Stacia. She was not actually the owner of the firearms, even though he is charged with theft of her firearms. So that is, I think, a huge issue. The other issue I wanted to bring up is he is charged with 2 counts of misdemeanor domestic violence, not felonious assault in that case, one of which is for an alleged threat, and one of which is for an alleged battery. And then, of course, the resisting and obstructing. I do want to note that the very first thing in the police report regarding the complaining witness's statement is an accusation of Elijah messaging his ex-girlfriend. And I think that's what this case is clearly about in terms of the jealousy, in terms of Mr. Kraft's relationships with both women and specifically the messages that day. I do want to note Mr. Kraft is a Marine Corps veteran who has been deployed twice to serve our country in Afghanistan. He has no criminal history, no convictions. His mother, Ms. Sonia Kraft, is here to support him. She has verified that he can stay with her in Southfield. She works from home. She'd be able to give him transportation to court. He could be on a tether if that would provide further assurance. Again, he's had no bond violations because he's been in jail since. And his stepfather is here as well to support him. So I would ask if this court would reduce his bond, specifically in the 0324 case, given all of those updates, which I think are relatively new since his reign.
Response.
Your Honor, people object to any modification of bond. In the first case, the defendant was at one of the victim's friend's house. An argument began. He went to a back room, was heard racking a gun, came back, pointed the gun at the victim while she was holding her infant daughter, and he then removed the magazine to prove to her that the gun was loaded. This was captured on an audio recording, their argument. And in the audio recording, it stated that you could be heard saying, if the police show up, I'm shooting her in the head. And then in the other case, it was another argument between him and a different victim, his girlfriend. He grabbed her arm, pulled her into a different room. The argument continued, and he told her, if you keep raising your voice, I'm going to slap the shit out of you. He then slammed her onto a bed and was kneeling over her and said if she hit him, he would F her up. And then in that case, she had 3 missing pistols and they were found in his car in his suitcase. I have extreme concerns for not only the victim in domestic violence case safety, but the other person's safety in the other case, who was just a friend. He pointed a gun at while she was holding her child. He does have a previous dismissed unlawful imprisonment FA and DV with the same victim on the DV case that was dismissed because she failed to appear. However, she is on board in this case. And I have extreme concerns for their safety given the allegations.
Anything else?
Your Honor, I just want to note that Mr. Kraft does adamantly deny the allegations. He has consistently been asking for a polygraph. We do have a potential witness who we are investigating further, but as to the main witnesses' credibility in terms of admitting that she didn't tell the truth about the allegations, obviously he is proven innocent of the allegations at this stage. Obviously, they are very concerning allegations, but the question is, are there bond conditions that can be set to ensure her safety as well as the community safety pending trial in this case? And I would argue there are conditions. So a GPS tether, no contact, which again, he's had he's given the court no reason to believe. And sorry, let me rephrase. He's given the court every reason to believe that he can and would abide by a no contact order. I mean, he's a Marine Corps veteran. He knows the rules. He knows how to follow them. And a GPS tether, no contact order.
And also how to handle a firearm and never pointed at anybody.
Yes, Your Honor.
Okay, just checking.
Yeah.
Go ahead.
So we would ask for a reduction bond in this.
Motion for bond reduction is denied. I will, however, set his probable cause conference out to April 3rd rather than 2 weeks.
Thank you, Your Honor.
Bond will continue. Thank you. For calls case, People versus Desmond Burton.
Jim Kennedy, after people, Your Honor.
Public Defender Chelsea Whitfield, on behalf of Desmond Burton, who approaches. Mr. Burton, please state your name for the record.
Yes, sir.
We're asking for an adjournment for both discovery and a plea session.
Probable cause conference, April 17th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Court does call the case People versus Gregory Davis. This is Ms. Yagi's case.
Yes.
I apologize, Your Honor. Lori Yackey, Assistant Public Defender, with and on behalf of Mr. Davis, who is standing to my right.
Your name, sir? Thank you.
So there's a couple, well, I think the main issue here, Your Honor, is missing discovery. I would ask for an adjournment in order to obtain via discovery that's referenced in the police report.
How soon can they get that?
Sorry.
There's discovery that's needed.
We sent everything. I think the issue is Sherry just hasn't had an opportunity to review it. Is that correct?
That is not, I do not see,
Okay.
unless it was within, was it this morning that it was sent?
No.
Was it as of yesterday? I did not have the surveillance video, the 911 call, and you said it would take a while to get time.
The 911 call will take a day or two to come in. I think the video, should have been provided to you yesterday. So we will follow up.
April 10th, 2025, 9 a.m. Bond continued. Court calls case, People versus Kristen Bird.
Okay, attorney, if you have any application.
Good morning, Your Honor.
Good morning.
Sorry, my camera's a little blurred.
It's okay. We got you. All right.
Assistant Public Defender Daniel Cleveland on behalf of Mr. Bird, is presently assumed. Sir, can you please state your name for the record?
Christian Bird.
Thank you, Your Honor. I'm respectfully requesting a very brief adjournment. I want to discuss this matter with the people. I do not believe I have a good phone number for Mr. Bird, however. So, Mr. Bird, can you please call the public defender's office, or email me back so we can talk? And then we will talk for the next court hearing.
Ma'am, I did receive your phone call. I just wasn't able to call you back. I can call you today, though.
Perfect.
April 17th, 2025, 9 a.m.
All right, thank you.
Thank you. Court calls the case, People versus Portia Elledge.
Assistant Public Defender Ben Dunn on behalf of Mr. Elledge, who is entering the courtroom now. Portia, would you please state your name for the record?
Yes, Portia Elledge.
Thank you.
Your Honor, the defense is going to demand exam.
It just has. All discovery complete.
Yes.
People have their witnesses available the 8th.
I will certainly try.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo.
Thank you, Judge.
Thank you. Bond continues. Court does call the case, People versus Robert Connolly.
Thank you, Senator. Yeah, people, Your Honor.
Hey, Matt, can we have Mr. Conley, who's approaching to my right? Can you state your name for the record?
Okay, you're requesting an adjournment?
Yes, we are still waiting for.
Without objection, probable cause, April 17th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case, People versus, is it Alua Gillis?
And is that on behalf of people, Your Honor?
Yeah, the assistant public defender on behalf of Ms. Gillis, she is incarcerated.
They don't have Gillis. Hold on a second. Who do they have?
They should have Lamar Jones.
Court calls case, People versus Lamar Jones. Is that who they have?
And is that on behalf of people, Your Honor?
Good morning, Your Honor. Alex Warren, hearing on that, Mr. Jones.
Mr. This one,
Lamar Jones.
this. Go ahead.
Your Honor, today's date and time for probable cause conference, I believe we reached a resolution. We're asking the court to consider my contest pleas to count 5 and count 6 on the complaint. In exchange, the people have agreed to dismiss the 4 remaining counts and have consented to sentencing.
That's correct, Your Honor.
So the assault and battery and the domestic violence charge and dismissing the other 4 counts. Is that what we're doing?
I understand.
Correct.
Raise your right hand. Do you solemnly swear to affirm the testimony about to give truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Say your name.
Lamar Jones.
Sir, it is this court's understanding that you're going to be pleading no contest to 2 charges. Is that correct?
Yes, sir.
First charge is that of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
The other charge, just stated count 6, is a charge of domestic violence. That's also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest these charges. Do you understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Basis of the no contest plea?
Lack of recollection, Your Honor.
Sir, to the charge of assault and battery, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes, sir.
Any question regarding any of those rights?
Yes, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal over it.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 259016. Any objection to the court having reviewed that report?
None.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Not satisfied.
Court will accept the defendant's pleas of no contest to counts 5 and 6. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 21st, at 10 a.m. before Judge Washington.
April 21st, 2025, 10 a.m. before Judge Washington. Bond will continue.
Your Honor, may I
Briefly.
Thank you, Your Honor. Last time Mr. Jones was before the court, he was remanded on a positive ETG test. Prior to that, he returned 2 negative ETG tests. And at the time he returned that positive ETG test, he was referred to community correctional outpatient. My understanding is he was forthright about that failed test with the supervision agent, with the court. This is his first interaction with the criminal justice system. I think after the court reviewed the police report, the court would know that this case is really about intoxication. With the people agreeing that 4A, we're just asking, we're asking the court to consider reinstating his bond so that he can kind of show that he's a good candidate for that purpose.
First round.
Your Honor, we'll leave it in the discretion of the court.
Well, how am I going to stop him from drinking?
Your Honor, I think he's going to.
Because that's where all the problems flow.
Won't be no issue.
You kind of said that to us before, right? You really never said that? So when we told you no alcohol, you thought it was going to be an issue?
No, I'm just saying it won't be an issue. I can guarantee you that.
Your Honor, if the court considers our request, I think Mr. Jones will immediately get himself to treatment. I think that he needs that and some kind of support group to just either, whereas I know that the drinking incident this time, my client tells me it was prompted by, him being separated from his family support system. If he were released from custody, he could be away from the complaining witness in this matter, staying with his sister. She's responsible community, who works at a local nonprofit. She'll keep an eye on him. sure he's not drinking or violating public justice.
Reinstate his previous bond conditions. But he's to report to community corrections for placement on a scram tether. I need an order.
Prior to.
Yes. Thank you.
Thank you.
Court calls case, People versus Nicholas Coots.
Peter Curry, appearing on behalf of people.
Assistant Public Defender Chelsea Reveals on behalf of Nicholas Cruz. Your Honor, I have contact from Mr. Gates. I was going to ask you here what's the probable cause conference for discovery purposes.
Yeah, consider it now. Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. Yeah, well, actually, I'm gonna make it 25,000 cash surety. He has a community corrections violation also. That warrant will issue immediately. Thank you. Court calls case of the People versus William Jones.
People.
The public defender, Ben Denham.
He's got to keep moving. Keep moving.
Mr. Jones, would you please state your name for the record?
William Jones.
Your Honor, my understanding from Mr. Jones' family that is present is that he's going to retain counsel, so we would ask the court for a 1-week adjournment so that he can do that.
April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case, People versus Antonio Cornelius.
Peter Curry, appearing on behalf of
Yeah, this is what better with Cornelius and Christian Podium.
Can you take your name for the court?
Your Honor, this is a case where we have restored of justice. And so I would ask for a 2-week adjournment. I'm hopeful that we can get the process started and or
Whatever that is. Yes.
subject.
April 10th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case of the People versus Alua Gillis.
And then on behalf of the people, Your Honor.
And Lori Yagi, Assistant Public Defender with on behalf of
Ms. Gill, can you state your name for the court?
Thank you.
Your Honor, I do believe discovery is complete in this case. We're asking that it be set for preliminary examination.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination will be set April 8th, 2025, 9 a.m. in person before Judge Barr. Bond will continue.
Thank you.
Court calls case of the People versus Sean Cotton.
Mr. Public Defender Chelsea Reveals with on behalf of Sean Cotton. Here is due. Mr. Cotton, please state your name. If you need to unmute, Mr. Cotton.
Sean Cotton.
We're asking to adjourn to work out some restitution issues in this case.
Probable cause conference April 17th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you. Court calls case People versus Glenn Page.
Public defender constantly based on the issues, but to my right. If I can just only for the record, please.
Thank you.
Directors indicate date and time set for PCC at the time of you. Respectfully requesting you set this for preliminary exam.
All discovery is complete.
That's my knowledge.
People have their witnesses available the 8th.
I'll certainly try.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Valvo. Briefly.
Mr. Honor, my client is going to be asking for a opinion bond in this case. This incident 5 years ago. He's already spent 13 days in jail. He's a lifelong resident of Miami. He lives here locally at the Huron Heights. He's hoping to not lose his Section 8 housing. He's got a job working for him, waiting for him at the Bellflower restaurant. We just asked that he be given a PR bond. I know he has another bond of 15.2. He's hoping to come to resolution of that case.
So he's being held on another matter? He failed to appear on this matter, which is why he has the one that he has.
Understood, Your Honor. This was not properly received. So I understood.
Notice was not properly received. What's that mean?
I don't think that he was aware of exactly when the date time.
So he wasn't told? Is that what he wants to relate to me?
He was homeless at that time.
But he wasn't told when his court date was?
Sorry,
He wasn't told when his court date was?
he was homeless, so I'm not sure if he received.
Your Honor,
Yes.
I'll just add for the record that I actually arraigned Mr. Page on this case and on November 17th of 2023, where he was arraigned for previously failing to appear for 2 days on this matter. So I can appreciate that he might not have gotten notice prior to that, but he certainly knew then when he was in custody given that date. But he also
That's what I was getting at. He was told the court date. And he didn't appear. Motion for bond reduction denied. Bond will continue. Thank you. Court calls case, People versus Thomas Lee Ellis.
There's a date time set for PCC requesting negotiations.
Is he on a tether or sober link? What was the alleged BAC in this matter?
this case, it looks like it was 0.13.
With priors. Hey, community corrections, so. All right. What did you want to do on this case? Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Or as your invite indicates, this bond will continue with the added condition defendants to report to the Department of Community Corrections for placement on its Graham tether.
Yeah, I have so.
Okay, that's what I was asking. He's on testing. You already have one. Okay, that's what I thought. Okay. Thank you. Court calls case, People versus Jacob Potter.
And said on behalf of you.
Yeah. Is that who they have?
Am I right? For the record.
Take a ballot, Senator Potter.
Thank you.
At this time, we're going to be respectfully requesting to set this for a preliminary exam.
All discovery is complete.
My knowledge.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before judge.
Can I
Bar.
address bond briefly?
You may.
My client is going to be asking for a PR bond. He has a place in Belleville where where he will be staying with a friend over on Rustic Drive. He's going to want to tether if the court deems that necessary. He just wants to get back to his job. He works at public disposal. For 50 hours a week there. He wants to get back to his job. So
Yes.
Your Honor, I was also going to ask the court to address bond, as he has made 52 calls to the victim from his pen since arraignment. In these calls, he says, "You gotta go to the prosecutor's office and tell them it's not written down right, that I live there too. I damaged the door, they're making it look like I just entered the place, I've never been there before, and that I'm your ex-boyfriend." He also says, "Go to the prosecutor's office and speak on our behalf, whatever, I can't talk to you." He also says, "This is a serious thing I'm going through, I don't know if you can help, I don't know if the prosecutor tomorrow or anything, I don't know. You need to leave your number out of anything you may sign, you know what I mean? If you, or the prosecutor or anything, leave your phone number out of anything that you might sign, that way they can't link you to my call history." And then he also asks her to get on the Text Now app they have in the jail, because we can't see that, and that's why he wants to keep communicating with her. So I have extreme concerns that he can't follow court orders and reject any modification.
I understand, Your Honor, I previously spoke to him. Understands that there needs no contact period. He just wanted to somehow give the information to the court that he lives at the address. Questions. But
He wanted to get that communicated to the person that does live at the address? That makes no sense.
I will just add that when he was at the address, he kicked the door open and entered the house without permission, and he began throwing her items against the wall and was intoxicated. So I have extreme concerns. I couldn't even go in here like that.
Defendant's phone privileges are revoked. Defendant's motion for bond reduction is denied. Bond will continue, but his privileges are revoked.
Understood, Your Honor.
Thank you. How's the case? People versus Sadie Padro or Padro?
As in, I'm happy, Your Honor.
I know it's Warren doing on behalf of Ms. Padro.
Well, thank you.
Your Honor, maybe briefly approach.
Okay, record to reflect, we read a bench conference in this case. So you retain counsel, so they'll be appearing at the next.
That's correct, Your Honor. I spoke with Attorney Joe Hall yesterday. He just asked me to kind of stay today, but I believe that they signed a substitution to be filed.
All right. Probable cause conference under those circumstances will be adjourned to the 10th, 9 a.m. or as your invite indicates. Ma'am, how'd you get here?
My mother.
And did you come just with your brother?
My mother. I just came with my mother, yes.
Only people in the vehicle?
Yes.
Okay, I want to admonish you because I noticed that you are within feet of the alleged victim in this case. You can't be near them. Understood?
Understood.
And because you're the one under the jurisdiction of the court, it's on you. So they can sit down and you just got to get up and try to move yourself away. Am I clear? With that admonishment, bond will continue. Thank you.
Yeah.
Court calls the case, People versus Scott Reese.
Sophia Curry, here to be on people. Stephanie Cantor, on behalf of Mr. Reese. Mr. Reese, when you're at the lectern, please take your name for the record.
Scott William Reese.
Thank you, sir.
Your Honor, I did file, I believe, a green sheet in this case. We're gonna ask for a 1-week adjournment. I've asked for some additional discovery, which includes 911 tape, proof of ownership of, where he is alleged to have broken into. My client.
Are they going to be able to get that to you in a week? I mean, I don't have a problem adjourning in a week, but they're gonna.
Probably not the 911 call. I have requested those items, but I'm not sure. I can request, I believe, yesterday.
But I don't think we'll have the 911 call.
But you'll have everything else in a week, and are you gonna need the 911 call?
Your Honor, it's alleged that they specifically identified my client in that call, so I want to see whether or not that is accurate.
Well, right, I got you. So it seems that that's rather relevant. And I'm gonna go 2 weeks out just because I want to make sure it's here. And you were going to anyway, so go ahead.
So my client does have a defense in this case regarding the ownership of that particular property. It's my belief that once everything is pulled together, it's going to show that he had every right to be there. He was paying rent on the property. He was basically subleasing from someone. And then the police just bust in and took him. So in the report, it even indicates we were trying to figure out who owns it. Well, I think that's important before we bust in and arrest somebody to figure out who owns the property. And so my client.
Really?
Sorry, Ron.
No, I'm just.
So I believe
that was very dramatic.
It is.
In terms of how you, no, in terms of how you said that. It just.
You can see the condition of my client, where he believed he was, and I believe that he was lawfully present. So we're just asking that he be released. I mean, the address is his address, as is the one next to it.
Well, okay, so here's gonna be the problem.
Yes, sir.
If I were to release him, he would go to that address, which at this point, I don't have anything. I mean, I hear what you're saying, but I don't have anything to say. It seems to me that there would be written documentation about
Yes, sir.
what you're saying.
So I've asked for it, and I'm doing an investigation request, but before the police go in, I do believe they also should understand.
Well, if you want to blame the police, I mean, they're gonna get their call, and they're gonna have to respond to the call. But council approach. Record should reflect we've had a bench conference in this case, and there's obviously something that's gonna have to be looked at. I'm gonna set this for the 10th. The motion for any reduction in bond or change in his bond, I'm gonna deny at this time.
Thank you.
All right, thank you. Court calls the case, People versus Justin Fowler.
And then on behalf of people. And I think we have Mr. Fowler, right?
Justin Fowler.
All right, what are we doing? I do have a plea form. Plea form indicates that the defendant would be pleading to count 3, which is MDOP, malicious destruction of personal property less than 200 in a domestic relationship, as well as domestic violence, second offense, the 1 year. That's the added count 4. Upon a successful no contest plea to those charges, counts 1 and 2 would be dismissed. There's also an agreement, although the court can't bind the sentencing judge to no upfront jail, but there is an agreement to pay full restitution. I'm assuming on all counts.
That's correct.
Sure.
Let's have them sworn.
You solemnly swear to affirm testimony about the truth, all the truth,
Yes. State your name. Justin Fowler.
All right, so it is this court's understanding that you are going to be pleading guilty or pleading no contest to 2 charges. Is that correct?
Sure.
The first is a stated count 3 of malicious destruction of personal property less than $200 involving a domestic relationship. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that, sir? All right. You're also pleading no contest to the charge of domestic violence, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You understand that?
Yes, sir.
You understand what a no contest plea is? 2 things about it I have to make sure that you understand. It first of all means that you're not desirous or wanting to contest these two charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty to these charges. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. All right. Basis for the no contest plea, counsel.
Civil liability.
All right. So, sir, to the charge of malicious destruction of personal property, less than $200, how do you plead?
Contest.
To the charge of domestic violence, second offense, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. Those are the rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on them. You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
Sure.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 25-13754. Any objection to the court having reviewed that report?
None of the people, Your Honor. No.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 28th at 10 a.m. Judge Washington.
April 28, 2025, 10 a.m. before Judge Washington. They'll do that. No, you're good. Bond will continue. He's out.
Modification, condition.
Oh, you want me? Oh. I read it.
Work and he travels a lot for work, so I was just asking if this court could remove home confinement.
Response from the people.
You're not looking for court's discretion, I'm just asking if you change them to a hot zone.
What is it? Is his current tether home confinement?
It's got a hot,
Pardon?
it's got a hot zone on it. And it's,
It should have a hot zone, but pardon?
I'm home to work, so.
So if he can go to work, what are you
He
asking?
has to travel for work in the next few weeks.
To where? Gaylord, you don't even know where that is, do you? You said it like it was a strange city. It's like Mackie has never been to Gaylord, Michigan. Because it's pronounced Gaylord, not. No, it's not two separate words. No, it's okay.
Gaylord, and that's why
We're in Michigan. She's gonna talk about Florida. So I guess the thing is, if under the current order, I don't know if I need to amend it, because under the current order, if he shows proof that he's supposed to be someplace else for employment, he should be able to go.
so what? Can I speak?
Sure.
All right. So
As long as you say Gaylord, not Gaylord. Anyway, go.
So I do travel, I do infrastructure repair. And like the times that I have had to leave, like Saginaw, Benny Flint, they give me extended hours out for those days. Like my earliest time I think I could have left my house was like 5 in the morning.
They extended your time for you to be able to get there and back.
Exactly. So like Gaylord, it's 4 hours to get there from my house.
I knew that. She didn't.
Well,
Go ahead.
So for me to get here all the way to
No, I hear you. So here's what you need to do. get an indication, or I probably prefer to do it this way. Get some proof from your employer that you're to be there.
Your Honor.
Get it?
I believe what Mr. Cole was trying to say is he travels even more than just Taylor, Michigan. He goes to other places and it would be a burden for him to always have to, because he doesn't know where he's going as a construction worker, and he kind of gets the job on the spot. So I think he's just asking.
Here's what I'll do. I mean, I get it. I get that, but he's going, who is that? I lost my train of thought. That was such beautiful music. I almost went to sleep. So when are you going to Galen?
It's not, I don't have it set in stone yet. It's, I think they have it scheduled for like the middle of April, what I understand, but it's not set in stone yet. It depends on a lot of variables up there. County. So that's kind of why I just wanted to see if I can have the GPS locator, but it's not a problem to have.
Okay, I'll sign an order indicating that as long as defendant provides proof of his, that he's got employment somewhere, defendant may travel to that location.
So every time he wants to do some work, he needs to do it.
No, what I'm saying, well, he would have to provide proof to community corrections for his tether purposes, but he doesn't have to come to the court every time. So that, because I get what he's saying, it's going to depend sometimes on what other people are doing, and then all of a sudden next thing we're called up to go. Get that idea. So what you would need to do, I'm going to give that order that you can go and do it. So they don't have to do extended hours. You'll be able to go. You just have to provide proof to community corrections that you have them, that you are supposed to be there from your employer.
Would it be okay to like stay out, like stay in Gaylord for, you know?
From my standpoint, yes, because you would you'd be working up there.
Right, it's not like I'm just on vacation.
In Gaylord, yeah, okay. So, no offense to anyone that lives there, but I'm just saying.
Yeah.
So, yeah, my intent, so that we're clear, my intent is to be able to allow you to go work. If you're someplace, why don't you just put this in the order? That if it's over 2 hours travel time, defendant may stay in that location. Okay, put that in the order. That way he doesn't have to worry about that. Okay?
Thank you, Your Honor.
You're welcome.
Regular, like in and out times to be back home, except for when I'm going out of town. That's kind of.
What? Are you trying to make this more complicated? I'm just.
Your Honor, I think my client is trying to say, does he still have to have a set time and date every time he needs to go to form probation, or can he just go?
I don't know. No, what I'm saying is, it seems to me they allow him to go to work.
Yes.
Right? And so they have the hours for that. That's what he'd have to abide by. But I get that there are times that he's, the whole notion of going to Saginaw and then having to come back and extend the hours, seems a bit much. It's going to certainly seem a bit much for travel to Galen. Right? But in the interim between now and sentencing, where Judge Washington can address it, I'm trying to set something in place that makes it a little bit easier. I'm not taking all of the guardrails off. I'm making it a little bit easier for him to be able to work.
Oh, yeah, absolutely.
Okay.
I appreciate that. Like I said, I don't have a problem with stuff. It's just the home confinement part, moving around, trying to get work.
I get you, but there's a reason why that's in place, but we're kind of loosening the parameters of that and allow you to work. Okay. Do you think, Ms. Mackey, you could prepare that order? No, we'll wait and we'll see what it says. I have to send it back, and then next thing I know, I gotta remember, review the transcript. It's gonna be a mess. All right, thank you.
Your Honor.
Let me see that over. Court calls the case, People versus Clarence Tomita.
Good morning, Your Honor. Jacob Kennedy, on behalf of the people.
Who is now entering the courtroom. Mr. Tomato, would you please state your name for the record? Did the court hear that?
Yeah, I do.
Your Honor, the defense would like to demand exam and we would like to address bond if it's okay with the court.
Discovery is complete.
We have one outstanding video, but the prosecutor has it. We just had to agree on the protective order, which we have done, so that's coming.
This protective order study is sent to the court staff, released by our office, to the defense counsel. So discovery is not complete at this time.
Hey, but have you signed off on the order?
I'm gonna send it to them.
Okay. And then you're gonna be able to view whatever it is, but then, all right. Would your witnesses, I really don't consider that complete, but. People have their witnesses available the 15th.
Yes, Your Honor.
I'll set a preliminary examination in person, April 15th, 2025, 9 a.m. Is that before Judge Moore? Before Judge Moore. As to bond.
As the bond, Your Honor, bond is currently $100,000 cash. This is a 4-year delay to court case. There has never been a similar allegation in the past. So I'd argue to the court, he can be tethered to his mother's house. He would like to get out to care for his elderly mother. The court could have, or set other hours if the court felt that was necessary. I'm sure the court would order no contact with minors during the pendency of this case. I do believe those conditions would be sufficient to protect the community. Mr. Hitchens has lived in the area his whole life. He's here with his elderly mother, so we don't believe he's a flight risk either. And we'd ask for personal recognizance bond.
Respond.
Your Honor, this is a case concerning from such a conduct in the second degree of a minor case. In this particular case, is accused of assaulting the minor for a period of 6 years between the ages of 4 and 10. During that time, reaching her shirt, broke her breast, touched between her thighs, kissed her on the mouth. Additionally, Your Honor, when deputies went to ask the defendant about these allegations, he told them as they were getting ready to leave, asked them actually if they could go shoot them, stated that he would not, the deputy stated they would not. And then the defendant started laughing and said, "I'm serious, man, this is fucking bullshit." So I have grave concern. That was the victim and the community. And I would actually ask the bond rates.
Your Honor, I think my client, essentially pleading not guilty to the police using colorful language should not be held against them. He certainly maintains his innocence. We'd ask for PR bond.
Motion for bond reduction is denied. I'm not going to raise it either at this point, but motion for bond reduction is denied.
Thank you.
Court calls case of the People versus Eric Fowler. Thank you. Did you and Bellinger coordinate suits? No, I'm just asking. Go ahead, Mr. Brown.
So yeah, we have approached the prosecution concerning this resolution. We may have to speak
with the officer.
The officer.
That's correct, Your Honor. I actually sent an email before the docket got started in the hopes that I might hear back by the time the case was called. I have not gotten a response yet. So I think we may be able to resolve, but if counsel is requesting an adjournment, I would.
So yeah, we have two options. If you want us to move the case forward, instead of that's fine. Or, based on what you told today, you can adjourn.
Why don't I adjourn it out to the 10th? And let's see what they say, because that's gonna sort of dictate what your client may want to do on this. April 10th, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you.
Thank you.
Thank you, sir. Court calls case People versus Christopher Garrett.
Sorry.
No, I was calling another case.
Good afternoon, or good morning. It's not quite afternoon yet. Good morning again,
Not
Your
yet.
Honor. Victoria Burton here as Chief Assistant Prosecutor appearing again on behalf of the people. Go ahead, Ben.
Sorry, Ben, I don't know if we have Mr. Garrett, you're staying to my right. This is for Garrett.
All right, what are we doing?
Your Honor, our office will be dismissing this matter.
Any objection?
No.
All right, case is dismissed. Okay, thank you.
Thank you.
Court calls case People versus Floyd Green.
On behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Green, Green constituent, Floyd Green. Your Honor, today's date time for probable cause conference, we are asking for the subject matter for preliminary.
What's going on out there? Discovery is complete then.
Please, sorry, Your Honor.
People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Valvo. Bound continue. Thank you, sir. Court calls case People versus Amanda Grove. She's on.
Assistant Public Defender Natalie Paper on behalf of Ms. Grove, Ms. Present via Zoom. May I please unmute and state your name to the court?
Amanda Grove.
Thank you.
And the children's apparently.
Thank you, Your Honor. I have discussed this matter with both Mr. Childers and my client. At this time, I wish to set the case for preliminary examination.
Discovery is complete. People have their witnesses available the 8th. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case of the People versus Mary O'Hearn.
Assistant Public Defender Jay Goins on behalf of
All right. Hey, you're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned without objection, April 17th, 2025, 9 a.m. Bond will continue. Thank you. Court calls case People versus Victor Jefferson.
Yeah, we're doing this to people.
Why is she walking across my floor? Yeah.
So sorry.
Victor Jefferson.
Thank you so much. I apologize. Assistant Public Defender Jay Goins on behalf of Mr. Jefferson, who's not present today, Your Honor. Last time we were in court, we were advised that he would not have to be present before submitting his own files.
That is the first thing, Your Honor, and
You're very dismissive. Case is dismissed.
Thank you.
Court calls case People versus Quincy Jones.
Your Honor, Alexis, the my assistant public defender on behalf of Mr. Jones. Mr. Jones, could you say your full name, please? Your Honor, we are requesting an adjournment today. I have been told that the people are reviewing a new warrant request, potential felony charges, so we just have to adjourn. So the charges are authorized to keep them together.
Yeah. How much time would we be?
Your Honor, so the warrant was submitted March 18th. I'll go ahead and assign that warrant to myself and get that reviewed before our next.
All right. So why don't I adjourn this one out to April 17th? Let's see how that works. 9 a.m. Bond continued. Thank you. Court calls the case People versus Maxwell Lawson.
Victoria Burton here as Chief Assistant Prosecutor appearing on behalf of the people.
I got the signal down here. Go ahead.
Lord, yeah, you public defender with on behalf of Mr. Lawson, standing to my right. Can you state your name to the court?
Thank you, sir.
Your Honor, I am optimistic and hopeful that we're going to come to resolution in this, but I believe sobriety court recovery court would be in Mr. Lawson's best interest. He is not a Washtenaw County resident, so I've been trying to follow up with 2 different programs in Wayne County. I don't have an update yet, so I am asking.
I'll grant an adjournment.
Thank you.
Probable cause conference will be adjourned April 17th. Let's see where we are at that point. 2025, 9 a.m. Bond continued.
And thank you, Your Honor. I just want to put on the record, and I don't believe Ms. Burton Harris extended an offer, and she indicated that it would remain open until the next date as well.
That is correct, Your Honor.
Thank you.
Thank you.
Court calls case People versus Tyler Pittman.
And Lord Yackey, Assistant Public Defender, with and on behalf of Mr. Pittman, who is standing to my right. Mr. Pittman, can you state your name for the court?
I'll adjourn. You're requesting an adjournment. I'll adjourn it.
Thank you.
April 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Calls the case People versus Larry Hickman.
Jacob Kennedy,
All these people are at jail. Okay, he's not here. He's at the hospital. I'll grant the request for an adjournment. I'll adjourn April 17th. And we'll see where we are. 2025, 9 a.m. Bond continued. Refusing. Court calls the case People versus Cody Jolly. He has no counsel. In this case, Mr. Jolly is once again refusing to come up. So, since he's refusing, not sure what we're ultimately going to do, but I'll just.
We're trying to petition.
Got it. Okay.
Next.
April 24th, 2025, 9 a.m. Bond will continue. Court calls case of the People versus Ryan Piper. He is refusing to come up.
Yes, yeah. It's the court receipt of a report dated March 10th, 2025.
I am.
Yes, it's from my understanding that Mr. Pickett has been found still incompetent to stand trial and likely due to incompetence. This
Right.
found that Andrea L. Vandenberg, we will stipulate to the findings of the.
Are you gonna be able to stipulate without your client present? Yeah, I mean, I'll adjourn this out to the 17th. You can figure out how you're gonna try to accomplish that.
Thank you.
Bond continued. Court calls case, the people versus Shaquille O'Neal Tubbs.
Oh, what a total failure this is. Good morning. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Who's he? Gentlemen?
Assistant Public Defender, defendant on behalf of Mr. Tubbs. And Your Honor, I understand from the deputies that my client did not want to be present today.
Yeah,
So
he does that occasionally.
when I spoke to him, he was looking forward to being present. So I guess I would just leave it to the board's discretion.
I'll adjourn it out to the 17th. He'll change his mind after a while, maybe. But we'll continue.
Thank you, Your Honor.
Thank you. Court does call the case, people versus Javon Mills.
And then on behalf of the people, and I was wondering about Mr. Mills, Your Honor, he's in the hallway. I can do it. Thank you.
Oh, somebody do it. Or is he in the hallway?
The hallway is fine.
Yeah, right. That's a good point.
Kitchen, Mr. Moss.
Okay.
Your Honor, today's date and time for probable cause conference. I've spoken to people about receiving media discovery. I believe that is in transmission. I have an adjournment request for here. I also have a stipulation post order for the court to consider relative to changing its GPS tether conditions. Mr. Mills wishes to attend the computer or this Friday is a visitation and this Saturday
is a funeral. And you stipulated to that.
I have a written stipulation.
That's correct, Your Honor.
All right. Oh, Detroit. Okay.
And Your Honor, I need the Hines blank on that proposed order. So I just asked Mr. if he could provide the court an idea of specific.
Well, go ahead.
So, obviously the visitation is tomorrow. What time do you need to be out of the house and return to the house?
Well, hold on a moment before you answer that. The visitation's from 3 to 8 on Friday. All right. This is your brother. All right. And then the service. Okay, I gotcha. So as I look through this. All right. And then the funeral. All right. I don't. All right, why don't we do this? I'm going to hand the order back to you. Have a conversation with Mr. Mills regarding that. My posture on it is on the visitation that it's going to, you live in Ipsy. All right. So on the visitation, my posture is going to be an hour on either side of that visitation time. Okay. And I think that should do that. The more difficult part's going to be well, I'll just ask you this, Mr. Melton. The family hour is not just an hour. That's the other part. So if I did 3 hours for family hour, you think that would be able to satisfy it? I mean, because some of it's gonna depend on how big your family, I mean. Yeah. All right, so what I'm gonna do for the family hour though is I'm gonna do 3 hours on that. Okay. Because it starts at 5. It says at 5 p.m. is when the family hour starts, right? Okay, so when I say 3 hours, here's what I'm gonna do. An hour beforehand, and then 3 hours actually of family hour, and then an hour to get back. Okay. And then on the funeral, that's at 5:30. So I'll let you fill in the times, but I'm likely with the funeral. Is there going to be procession to the site after the funeral or? Yeah, after, okay, and that's not on here. So talk with him about that and where that's going to take place so that I'm going to be flexible with the time frame because I get it's not going to go. You can't, some of the stuff you can't schedule. You don't know. Okay. So fill that out. I'm not going to have a problem with much of that if people know. Okay.
Thank you.
All right. I'll adjourn.
Can we go on 1 week conference?
Just 1 week. He's out of
Anticipate
custody.
we received the media tomorrow.
I'll go out 2 weeks. I'm not gonna go out. Probable cause conference April 10th, 2025 at 9. Or as your invite indicates, bond will continue. Okay. All right. Thank you. And sir, I'm sorry about your loss. Court calls the case People versus Robin D. Noble.
It is now afternoon, so good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
The public defender Natalie P. on behalf of Ms. Nobles, Your Honor, who is not present yet. She is currently on a bus on the way to Ann Arbor.
Yes, because we have a violation. She was appeared.
Yes, and I have spoken or emailed with Ms. Bureau of the Community Corrections and did confirm that my client does have an intake appointment scheduled at Community Corrections for 2 p.m. tomorrow. And Ms. Nobles is on her way here to court in person. I did provide the court via email a copy of the bus ticket as well as the people. She's not set to arrive until 3:30 p.m. However, I know
3:30.
3:30 in Ann Arbor, Your Honor. Yes.
Where is she coming from?
I forget the city on the bus ticket. It's from several hours away. And she departed at 9:15, I believe it was this morning. It's either 9:15.
Okay.
But it's before consider passing the
What do you want me to do? Issue a bench warrant and then recall it when she gets here at 3:30? I'll pass.
Thank you so much, Your Honor. I appreciate it.
Court calls the case People versus Derek. Is it Venerados?
Thank you, Richard.
Venerados. All right, what are we doing?
I'll be requesting a brief adjournment for further negotiations, approximately 2 weeks.
Do I have a sheet from you?
Okay.
Not objection. Probable cause conference April 17th, 2025. 9 a.m. Bond continued. Thank you. Court calls case of the People versus Aaron Piccini.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Public Defender Chelsea Fields, written on behalf of Aaron Piccini. Mr. Piccini, please state your name.
Aaron Piccini.
Yeah, usually when people do.
We filled out the referral form and sent everything to the 14 report, but you're still waiting to hear back.
So they've not set an interview time yet or anything with them.
I don't believe so. Mr. Piccini, have you been contacted by anyone at the 14B team?
You're muted, Mr. Puccini.
Okay, I'm already in drug court. They were just waiting for this to get sent over. They're gonna sentence it along with my current drug court.
Got it. Okay. So I'll just go out 2 weeks and see if we can get this resolved to get this case over. Okay. Probable cause conference April 10th, 2025, 9 a.m. or as your invite indicates. All right. Thank you, sir.
Thank you.
Court calls case People versus India Robinson.
On behalf of Ms. Robinson, who is present in Zoom, may I please unmute and state your name for the court?
India Robinson.
Thank you, Your Honor. I have had the opportunity to review discovery with my client. At this time, we wish to set this case for preliminary examination. Discovery is complete to our knowledge.
People have their witnesses available on the 8th. Preliminary examination in 8th, 2025, 9 a.m. That is before Judge Valvo.
Your Honor, if I may briefly address Commissioner Garman.
Yes.
Thank you, Your Honor. So this is charges to OWI third offense, and Ms. Robinson is currently on a spring tether. To my understanding, she is completely compliant. She resides in Detroit and is not currently driving, so has to take the lift every time she appears for community corrections for her scram downloads. She states to me that it costs $50 each time she has to come to community corrections for the download. She is asking if the court would consider switching her to a SoberLink device rather than a scram tether. She understands as many times a day as the court would want her to blow into that. She, of course, has not been on any substances since her arraignment or actually prior to that. To be candid, I told her that the court was unlikely to change it, but we are making that request that the court would consider switching her from the scram to the SoberLink due to the cost it takes her to come here to the downloads.
Did the people have a position?
I'm sorry, Your Honor, I couldn't hear.
Do the people have a position on the testing?
Your Honor, so I am not in position of any results for Ms. Robinson. But trusting that counsel's representation is true, I don't actually have an objection to SoberLink. Sometimes that's the preference of the committee with faster. So I believe that's the discretion of the court. I will note that the BAC.
That's what I was looking for.
77.
Yeah, that's why. Yeah, I mean, part of the reason that was probably likely skipped by the setting of it is her BAC was a .277, and there are, at least as indicated here, 5 alcohol related convictions. So I'm not going to change that. Motion to change your denied.
Understood, Your Honor. Thank you. And thank you, Ms. Robinson. We'll be in touch for your next court date.
Thank you.
Court calls case People versus Cynthia Sutter.
People. Recognition having Ms. Soto, please be viewed via Zoom.
Ms. Sutter, I need you to turn your camera on and unmute.
Okay. I am
State your name, please.
Cynthia Subtle.
All right. What are we doing?
Hopefully it's unmuted. I can't see you, but I'm hoping it did what it was supposed to.
You are unmuted. We can hear you and we can actually see you.
Okay.
All right. Thank you.
You're
At
welcome.
this time, Your Honor, we'll be requesting approximately a 1 month adjournment. Ms. Sutter, this is working towards paying restitution. Work toward the resolution. Added, she just needs about 1 month to pay that last amount. She did just make a payment of $1,000. So she is making good progress. She just needs the last little bit of time to pay that last $300 worth of restitution.
Okay. Do you have a green sheet? I don't have a problem. I'm sure there's no objection from the people. April 24th.
Thank you.
2025, 9 a.m. as your invite indicates. We'll continue. All right. Thank you, ma'am.
Thank you, Your Honor.
Court calls the case People versus Davian Thomas.
Andrew Phillips, appearing on behalf of.
Your name?
Your
All right, what are we doing?
Honor, today's the date and time for the cause conference. This matter has previously been adjourned so that Mr. Thomas could complete mitigation of the social work team. That has been completed, it's been provided to the people. We're asking for adjournments that may be considered, and we also need to determine restitution.
April 17th, 2025, 9 a.m. Do I have a green sheet?
I do.
Bond will continue. Thank you. Thank you. Court calls case People versus Delco Thomas.
Alex Warren, great on that, Delta Thomas. Your Honor, I have been unable to reach Mr. Thomas. I'm not sure if he
Delco Thomas, your bench warrant. Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately. Court calls case People versus Matthew Turner.
On behalf of Mr. Turner, who appears on Zoom. Mr. Turner, would you unmute and state your name for the record?
Matthew Turner.
Got it.
Your Honor, the defense would like to request an exam.
All discoveries complete.
Yes.
People have their witnesses available the 8th.
I'll do my best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Barr.
All right, thank you.
Bond continued.
Thank you.
Thank you.
Court calls the case People versus Adrian Vasquez.
Andrew Phillips, appearing on behalf of.
Here to my, right.
Adrian Vasquez.
Thank you.
Your Honor, my client is going to go ahead and set this for a preliminary exam, to
All discoveries complete.
the best of my knowledge.
People have their witnesses available the 8th.
That's fine.
Preliminary examination in person, April 8th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue. Thank you. Court calls case People versus Jelani Wright.
Stephanie Cannon, on behalf of Mr. Wright, is appearing to my right.
Thank you.
Your Honor, I did have a little, issue getting in touch with my client, we'll say, so I'm just asking for a couple weeks adjournment so that he can go over everything that I do have. We did ask for security footage and, one other piece of discovery, it's come to my attention that I've been told they don't have it. So at the next hearing, we'll either be setting it for a preliminary exam or leaving it up.
April 10th, 2025, 9 a.m. Bond continues.
April 5th, Your Honor.
10.
Thank you.
Court calls the case People versus Ernest Zazar.
Andrew Phillips, appearing on behalf of the people.
Your Honor, Alexis Pullman, appearing on behalf of Mr. Cesar. Who I do not believe is present today. Your Honor, I wasn't able to get a hold of Mr. Cesar. I was going to just ask for an adjournment. In this case, he was referred for mitigation report from our social work department, just started that process and had an interview this past Friday. That report is not yet ready.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. That warrant will issue immediately. Court calls case People versus Makisha Malcor.
Andrew Childers, attorney on behalf of People, Assistant Public Defender, on behalf of the Knocker. Your Honor, we're here for PCC today. My understanding is that we adjourned this case last time so that Ms. Melcher would be able to enter into treatment, complete that treatment. However, if the court recalls, her fiance passed away recently. She did have to take that time, unfortunately, to move her things out of that home. She just showed me proof that she's going to be entering positive images in Detroit today, right after court. I would ask for another month so that she can get in and complete that treatment.
Any objection from the people?
No objection.
Is that a 30-day program?
30 plus, it's just about.
Gotcha. So let's do this. Let's adjourn this out May 1st, 2025, 9 a.m. That we have a better handle on where she's at if she's going in today.
Thank you.
All right. Thank you. Court does call the case of the People versus Eric Smith.
Assistant Public Defender Natalie, Mr. Smith, Your Honor. I called him at 12:05 when this afternoon I received a notification from the court that he was to be in person today, that his case was authorized. I did call and speak to him, and he did inform me that he did have transportation to get here by 12:30. I told him to do everything in his power to try to do so. I can tell the court that I do know for a fact he's not driving right now. He also has a leg injury. His mother is his transportation. I met with him in person here in the office last Wednesday. His mother drove him to that meeting. They both came here together. He has a cast on his leg. That's last Wednesday. I would ask the court to adjourn this matter so that he can come in person and have his ride scheduled possibly next week or the week after. I do believe he would be able to get here in person if he had time to arrange a ride. I do strongly believe that throughout my representation of him.
And Your Honor, I did want to place on the record, this morning I was checking the warrant queue for deeds and I saw he did have a warrant. I authorized charges of misdemeanor domestic violence and malicious destruction of personal property, I believe 200 to 1,000. He was at the victim's house. He's not supposed to be the victim in the case we are currently on. And he was at her house, broke her TV, pushed her in the face. So kind of similar instances.
Was that after his arraignment on this case?
This was this morning at 1 a.m. He was there.
Oh.
Yes. So he did get picked up. He was at her house threatening to assault her and broke her TV, pushed her in the face.
So he could get a ride there.
Your Honor, the first I've heard of any of these allegations that
Yeah, I know. You can say that word as loud and as long as you want, but
the first I heard of this was during the 9 a.m. block. Ms. Zenda did tell me about that the case was in the warrant queue. To my understanding, based on those allegations at the time, he was not arrested on scene or anything of that nature. To my understanding, I firmly believe he would have been here in person if he knew far in advance that he just doesn't have transportation today.
And in the report, it says that other deputies were able to find his vehicle outside of his residence. They attempted to make contact, but no answer. So they didn't get a chance to talk with him. He was not at the scene. I also wanted to put on the record there was an offer given this case at this time. People be presenting that offer.
Anything else?
I would ask for a very brief adjournment, Your Honor, so that you can get here in person.
Bench warrant will issue for defendant's failure to appear. Given what I've heard, there'll be no bond. That warrant will issue immediately. So if he doesn't get here, then we'll get him. Oh, yeah, gotcha. Court does call the case, People versus Caleb Smith.
Thank you, Judge. Good afternoon.
Good afternoon.
Lawrence Margolis on behalf of Mr. Smith, the date time set for PCC. I've spoken at length with sisters, and we are going to waive the exam.
Is that a correct statement, Mr. Smith? You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing, and you'll proceed to circuit court for further resolution. People also waive their right.
That's right.
Preliminary examination having been waived, defendant is bound over to circuit court on all four counts. Mr. Margolis.
Judge, we would waive formal reading and ask for enter not guilty.
Defendant, having waived formal reading, pleading not guilty, court will enter that not guilty plea as to all counts. Pre-trial in this matter.
May 15th at 1:30 PM with Judge Slynn.
May 15th, 2025, 1:30 before Judge Slay. Young man, how have you been doing?
Doing good, focusing on school. Chores around the house.
You doing chores around the house? You weren't doing those before?
No, continue into this, an update.
I hate talking to kids about chores because they're not telling me the truth. Mom, is he doing the chores around the house?
Yeah, painting and washing walls.
Really?
Yeah. I volunteered to help some of the kids at the after-school program that we have.
So he's painting?
Yes. Washing walls.
Can he paint?
Yes. You do all right.
He doesn't? Oh, just, okay, all right. Okay, she said, I don't trust him with all the colors. Young man, you've been through some stuff here, right? I don't do it to be mean to you, but I'm just going to tell you, there are going to be a lot of times you're going to come across some stuff in your life where you're either tempted to do something or whatever. Think back to the moments that we've had here as an example of some of the bad things that can happen if you don't make the right decision and don't do what your mama taught you. You hear me?
Yes, sir.
God will continue.
Thank you, Judge.
Thank you.
Thank you for having this case. Judge.
Thank you. Yeah. Take care.
I will continue to enforce the court.
Please do. Because I don't need a court to ride up on you. You hear me?
Yes.
I'll just, if you see a big Ford truck coming at you, you know it's me. All right? Hey, take care. Tonight. Tonight, and we don't need luck.
Okay.
Your team. You just call them your team. He must be a Spartan. He must be a Spartan because he doesn't know how to spell terrapin.
People not.
Oh, is that it? Okay. Wow. Court calls the case, People versus Quenisha Thomas.
And then I've got the people, Your Honor.
And good afternoon, Your Honor. Sitting rushing at the behalf of Ms. Hobbs, who is approaching the view to my right. Petitioner, your record, please. Thank you. Your Honor, at this point, we need some additional time to complete discovery.
All right. 17th work for you?
First, we judge.
Probable cause conference will be adjourned April 17th, 2025. 9 a.m. as your invite indicates, bond will continue.
Thank you so much.
All right, thank
Have a
you.
great day.
You do the same. Court calls case, People versus Lawrence Savoy.
And here return the people.
Good afternoon, Your Honor. David Aaron, Lawrence Savoy.
Thank you. All right. I have before me a plea form. Is that what we're doing?
It is, Your
It's going to plead to OWI second offense, the 1 year offense, Upon a successful guilty plea to that charge, count one would be dismissed. Counsel approach, please. All right, record should reflect a bench conference in this case, and we're going to go ahead and complete. He has signed an aggressor. Yeah. All right. May I have him sworn?
You solemnly swear to affirm the testimony you about to give the truth, the whole truth, and nothing but the truth, so help you God.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense. Is that correct? That is a misdemeanor. It is punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. That's right. Court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could also order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir? All right. And understanding that, I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Understand that? Correct. All right. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Correct.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
Because you believe that you are indeed guilty of this offense?
Yes, sir.
October 31st, 2024, at the location of William in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What'd you have and how much?
It was a couple of documentaries.
All right. Were you stopped by the police or was there an accident?
Stuff like that.
All right. Why'd they stop you?
Speeding.
All right. Were you ultimately arrested?
Yes, sir.
You were taken to the station or to the hospital?
At first the hospital runner and then the blood drawn.
Okay. So there was a blood draw at the hospital?
Correct.
What were the results?
Stipulated was a 0.127 blood test.
All right. You don't have any reason to dispute those blood test results,
No,
do you, sir? All right. And had you previously been convicted of operating while impaired on or about August 29, 2013 in 1483 District Court and or operating while intoxicated on or about August 3rd, 2017 in the 48th District Court?
Yes, sir.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people was satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 15th at 10 a.m.
May 15th, 2025, 10 a.m. before Judge Washington. Bound with its conditions will continue. All right, thanks. Court does call the case of the people versus D'Angelo Green.
Amber Joe is appearing on behalf of people, Your Honor.
However, on behalf of Mr. Green, please introduce yourself to court.
What are we doing?
Today is the end times at the probable cause conference. We have reached an agreement where people will be dismissing count 1. In exchange, Mr. Green will be pleading guilty to counts 2 and 3, the driving without a license and the no insurance charge. The people also agreed to not charge a count for brass knuckles that arose out of this incident. That's more for the record, the last, rather than not the uncharged part.
So he's going to be pleading guilty to counts 2 and 3. Count 1 will be dismissed. May I have him sworn?
Solemnly swear to affirm the testimony you about to give the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Raise your hand.
Yes, Lord.
Sir, it's this court's understanding that you're going to be pleading guilty to the charge, to 2 charges. 1, of operating a motor vehicle without security. That's a misdemeanor punishable by up to 1 year incarceration, not less than 200, not more than $500 fine plus court costs. You understand that?
Yes.
All right. And also to count 3, which is driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Your vehicle could be subject to a mobilization. You understand that, sir?
Yes, Your Honor.
Understanding all that, still wish to plead guilty to the charge of operating without security. How do you plead?
Yes.
To the charge of driving while license suspended, denied, and or revoked. How do you plead?
Yes.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Look on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe you're guilty?
Yes.
Okay. On November 18, 2024, at the location of 4001 South State Street, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Did you have proper insurance and or security for the operation of that vehicle?
No.
Did you know that you did not?
Yes.
All right. On that same date and at that same location that you were operating this motor vehicle, did you have a driver's license?
Yes.
Was your driver's license suspended, denied, and or revoked at that time?
It was suspended. I was unaware at the moment.
All right. Okay. So it was suspended, correct?
Yeah.
Okay. And you are not disputing that the Secretary of State sent notice of that suspension to your last known address? All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied. Defense is satisfied.
Court will accept the defendant's plea. 2 counts, 2 and 3. Count 1 is dismissed.
Your Honor, just a bit of backstory. This plea came out of an agreement between Ms. Blondie and Mr. Burdell. The defendant to complete 20 hours of community service, which eventually gave rise to that. People would have no objection to the sentence.
Okay.
And so, and he also did complete a gun safety class as well. He is currently insured and his license is valid as well. We would have asked for immediate sentencing at this time as well.
You say he has valid insurance at this point.
Yes.
And your license is good, whether you know it or not? Is it okay? All right. So anything either of you want to say before I impose sentence?
No, Judge, I know Mr. Green has learned from his mistake and he's ready to move forward. He's cleaned up his licensing issues and his gun issues. We're I'm confident he'll never need my services again. We just ask for immediate sentencing and fines and costs only.
On each of the counts, assess fines and costs of $295 on each count. Suspend 90 days in jail on each count. When can you get that paid, sir? You can pay those immediately?
Yes, sir.
It's about 600.
My next paycheck.
So I don't know when that is.
1 month, Your Honor, would that be able to give him a month's pay?
A whole month. It went from today to a month? It's Verdell's fault? No, it's not his fault. It's your fault.
I'll fall on that, Judge. I'll fall on that. So just to, give him a little extra leeway, just in case.
Pay it by April 30th.
Thank you, Judge.
All right, 2025. All right, bond will continue. Thank you, sir. Court calls the case People versus Bianca Rao.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor on behalf of the people.
Hi, Odell, on behalf of Ms. Rao. Ms. Rao, can you introduce yourself?
Hello. Seems kind of happy. All right.
Your Honor, that may be because we did receive an offer from the prosecutor
which we are intending to take. That will require her, Ms. Rowell, some time to complete some terms.
Okay.
So we are asking for a 30-day adjournment to allow her time. Thanks.
No objection from the people?
No objection.
All right. Probable cause conference on adjourned to May 1st, 2025, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you.
Thank you, Your Honor. Have a wonderful day. You are all set.
You do the same. Be
Thank
well,
you.
please.
Thank you.
Court calls case People versus Ahmad Holiday. Oh. Mr. Murray, did you want to state your appearance, please?
Oh, I didn't hear the people. My apologies. Good afternoon, Your Honor. James Murray, PA 5490 on behalf of Mr. Holiday. Please state your name for the record, sir.
He said it very well, but he was muted.
Unmute and state your name for the record.
My apologies, Ahmad Holiday.
All right, thank you. All right, what are we doing?
Your Honor, I sent the deviation request to the people, but I have not had a chance to discuss that with them. If maybe we can, well, it might be hard to go into a breakout room, a brief phone call and then come back to the record.
No, that's not going to happen. All right, you guys can use the phone anytime. You don't have to use it on my time. So I'll adjourn this out April 10th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Your Honor, may I address bond?
Sure.
At this time, my client is currently on home confinement tether. And while we have no objection to the tether at this time, the home confinement portion of his restrictions do prevent him from working. So we just ask that it be switched from home confinement to GPS tether.
Any responses?
Your Honor, I would not have an objection if the defendant provided where proof of employment, date, time, location of where he's going to be working.
Okay, so why don't we do this? Since you got to come back on the 10th in any event, I'm going to deny your request at this time. However, if there's a stipulated order after you supply all that information and talk about the case with the prosecutor in the case, I will sign off on it. I don't have a problem with it.
No, that sounds perfect, Your Honor. Thank you.
Thank you. So bond will continue as it is at this time. Thank you.
Great day to you and your staff.
Court calls case People versus Donald Spalding.
Sophia Perry, if you're going to have the people.
Good afternoon, Judge Arnold Weiner, on behalf of Mr. Spalding. Mr. Spalding, state your full name for the record, please.
Donald Spalding.
Thank you. Judge, this is the date set for another PCC. Last time the court adjourned it so we could see if we could get the discovery materials. The people have worked diligently and provided me all the videos that were in there. The only thing I am waiting for, and I think the people are waiting for, which would really make a decision whether or not we go ahead with the preliminary exam, is whether or not they have any lab results back on the bag of drugs that they found. I was specifically looking for whether or not they had any fingerprints or DNA taken of that bag one way or the other. So that's where we're at. But as of a couple of days ago, I was advised although they were working very diligently, the MSP has not provided them with that information. So that's where, at least that's what I understand.
Please.
So we did provide discovery back in November of 2024. And I believe there may have been court-appointed counsel, so that discovery was provided to Mr. Weiner, and we just recently provided Mr. Weiner with the MSP videos. However, I did reach out to the OIC to have the controlled substances sent to the lab for confirmation. There was a true narc done on the controlled substances. But as far as DNA, if Mr. Weiner wants to stipulate to an order to have the DNA testing taken from his client and make that request, we could send the narcotics to the lab along with his DNA for comparison. But that's not something that, based upon the facts of this case, we don't need DNA at this point to proceed for a probable cause standard. And I don't even think at trial, based upon the facts that we have before us.
Okay, well, I just wanted to know, Judge, that whether they were proceeding with or without, that there was DNA or fingerprints on the baggie. So if that's their
Sounds like that's without.
Yeah, I'm ready to set a preliminary examination date then. Thank you.
People have their witnesses available the 8th.
Judge, can we go other than what dates does this court prefer to do it on?
Well, it may not be me, but we do them every Tuesday.
I tell you what, if I'll be available on the April the 15th, if it could be done in the afternoon, or April 15th, I'll be available in the afternoon, Judge. If we could do that.
All right, counsel, just give me a Tuesday morning.
The 29th, I'm free, and I'll mark that off right now.
The 29th? Hold on.
April 29th, yes, sir.
All right, so I'll set preliminary examination in person, April 29th, 2025, 9 a.m. That will be before Judge Barr.
And that's going to be at what courthouse, Judge?
That will be at 14A1. That'll be at the Service Center.
Okay, thank you.
It's at the same courthouse that I'm in.
Okay. Oh, one off.
Okay.
Hog back right there. Okay, gotcha.
Yes, sir.
Thank you.
All right, thank you. Bond will continue. Court does call the case. People versus Jack Monitz.
Amber Children's appearing on behalf of the people.
Joshua Kaplan on behalf of Jack Moniz. Jack, will you state your name for the record?
Jack Moniz.
What are we doing?
There's been an offer in this case. It's my understanding that the defendant will be pleading guilty to count 2, the aggravated assault. People would dismiss count 1, assault GBH. There's no objection for the defendant to seek fight on.
Okay.
And Your Honor, that is our understanding of the plea, and we do accept that.
All right. Count 2 and dismiss count 1. All right, Mr. Monitz, if you please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
State your name again for the record.
Jack Moniz.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
And I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
Do you understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty? I'm sorry, you broke up. Your response?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today? I may have said that one. Has anybody threatened you or coerced you in any way to get you to plead?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And because you believe that you indeed are guilty of this offense?
Yes, Your Honor.
October 10th, 2024, at the location of 1015 Rapid Run Circle, apartment 206, Scioto Township, Washtenaw County, state of Michigan. What did you do to a Charles Chad that makes you think that you're guilty?
It was a verbal altercation turned physical.
Okay. So what happened?
Basically, he ended up coming there, like following my girlfriend, stalking her. And
Your Honor,
then-
if I may I have one here?
Please, yes.
Mr. Mooney's, on the night that has been mentioned, did you go outside and meet with the complaining witness in this case?
Yes.
And at that point, did you hit Mr. I forget his name, the complaining witness?
Yes.
All right. And
you hit Mr. Go ahead.
No, that was gonna say, and you hit him, and then a physical altercation occurred after that, correct?
Yes.
I believe that's enough for the for the case, Your Honor.
And are you disputing that he was injured as a result of your hitting him?
No.
Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
We accept, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
May 19th at 9 a.m. Judge Fresh Hour.
May 19th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Have a good one.
All right, you too. I thought I was going to have to listen to like a high school romance thing. And it's late. I didn't want to do that. Glad counsel took over. Court calls the case, People versus Jeru Gidry.
Company Curry, people.
David, I will state a frame on behalf of the defendant. So we just take your full name. Roll for you, sir.
Thank you. Sir, Your Honor, that be one works. That's fine. All right. Mr. Goldstein, we missed you.
I'm back.
I know. It warms my heart.
Not mine.
Yeah, okay.
Personal judge. Judge, we need to set this for an exam. I have written discovery. Miss Curry assured me this morning that there is no electronic discovery. So,
all right.
Not a double check that.
Yeah.
All right.
Knowing this case, I'd be surprised if there is, but yeah.
All right. And would the people have their witnesses available the 8th?
I would do my best, Your Honor.
Miss Curry knows if there's a problem, but we'll work something out.
All right. So preliminary examination in person, April 8th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you.
Thank you. Thank you, sir.
This season went forward. Okay.
What's that about? Basketball season.
Sorry, calls online, Your Honor.
Oh, no. What you said was not online. Talking to him is. I mean, I'm just, no. I'm just saying. No, you're okay. Take care. Court calls the case People versus Baiyang Wang. All right. And you're requesting an adjournment?
Yes, please. We are deep in discussion and probably just one step away from a resolution, but that step we still need to take.
Probable cause conference, April 17th. Does that work? The 10th? You want the 10th?
Yes.
That's right.
Thank you.
April 10th, 2025, 9 a.m. Or as your invite indicates, bond continued.
Thank you.
All right, thank you. Oh, and she left. Can you run? Oh, there she is. Miss Faye? Where did I have nothing left other than your bus traveler.
Yeah, she's still not here. It gets in at 3:30, the Ann Arbor station.
Okay. Were you able to talk to Miss Burton Harris? She signed up.
That information, she has not responded. One period.
Okay, so she has a meeting with community corrections at 2.
Ms. Nobles does, yes.
Miss Nobles does? All right. So rather than waiting, and you can try to get to her when she arrives at 3:30 or whatever. Okay, I think what I'm going to do. Was anybody going to cover this for Miss Burton Harris?
I can.
They all looked up like, what? That was a no.
No, I was gonna say, I can also send her a message, she might reply in like 2 seconds. I'll back on it for her too.
We did send her a message. We all.
Yeah, we'll stay.
We're fun.
It's a big family. What it is.
But she gets off the bus at 3. What time is it?
3 times.
Oh, so we're just another 20 minutes from her getting off. And then you may be able to contact her, right?
I've been kind of talking to her. I think I can talk to my boss.
Oh, great. I guess that would make sense. It's not an airplane. Okay. I don't even know what I was thinking. All right. Did she have a preference?
Ms. Nobles?
Yeah.
No, I've not talked to her about that.
Okay. So let's do this. It's only another 20 minutes. Why don't we just wait it out, let her get in, and then we can see where we can head with it. And I've been assured I'll have a prosecutor here. So that's you know what? Write it down on a piece of paper. I'll write my favorite choice on a piece of paper. Let's see if it matches.
But
what?
my big
Wow. Wow. When we call that case, that ought to work out real well. All right. Wow. And Paige just said it out loud. She just. Yeah, but we know it's not. All right. What? Wow. Wow. You know, when she first came here, she was so quiet and demure, and something happened. All right. Anyway, what I will do is I will step off. You'll apologize to your folks, and then we'll see what we're going to do once she gets in, okay? Court does call the case of People State of Michigan versus Robin Noble.
If you ever do that for people.
Yes, ma'am.
Assistant Public Defender Natalie on behalf of Ms. Robin Noble.
All right. All right. So, this was passed. All right. Okay, I have a violation from community corrections. So, did you
Yes,
want to
Your Honor.
address that first?
Yes, Your Honor. And I have received that and had the opportunity to discuss that with my client. And then was able to confirm with community corrections that Ms. Nobles did then reach out to community corrections this morning and scheduled her intake appointment. It is set for tomorrow at 2 p.m. Ms. Nobles did yesterday evening, upon learning of now the in-person requirement for today's hearing, she purchased a Greyhound bus ticket, not Greyhound another bus line. In any event, she made it here and she is planning on staying with her sister in this area so that she can complete that intake tomorrow and test at community corrections as needed. I have been in discussions regarding this case with Ms. Burton Harris. Ultimately, we're requesting a 2-week adjournment. I believe the case is one that's going to be resolved. I will be asking for 2 weeks so that Ms. Nobles can complete her community corrections intake tomorrow afternoon, get on testing there, and then the resolution can happen at that date.
Anything from the people regarding any of that?
No, I am standing in for Chief Assistant Burton Harris. I have not had an opportunity to discuss this case directly with her in given circumstances. However, I was present earlier during the docket where she was aware that Ms. Nobles was on her way, and I will take counsel's representations, and her word is true. And I have no objection to the adjourned request.
Probable cause hearing will be adjourned to April 10th, 2025 at 9 a.m. Were you testing in Grand Rapids?
No, so I was supposed to move in on Wednesday, but my original bus ticket, the public transportation engineer didn't pick me up on time, so I missed that very home. And the next ticket that I was able to get was scheduled to come here. As I learned that I was supposed to transfer it. But I am still supposed to be down. I can communicate with the property owner in that recovery room, and they know that I have court movements. I let them know everything that is going on. I still plan to move in. I just want to make sure.
Move in where?
Recovery room in Grand Rapids. That's the sober living facility.
Because 10 days ago, when I ordered that you could test in Grand Rapids, and it was supposed to be 2 times per week, there's been no testing.
No, not yet. Because I haven't yet.
I did directly confirm myself with Ms. Kerpoki over at Community Corrections that she does have her intake scheduled for tomorrow.
28th.
Yes, sir.
All right, what I will do is I'll adjourn it to the 10th. Her bond will continue. I will indicate a condition in that bond is that she's to complete her intake at Community Corrections and to test tomorrow. All right. Okay. Anything further?
Yeah, sorry, nothing further from me.
All right. Thank you.